भारत दुनिया का सबसे बड़ा लोकतंत्र है। हमारी संसद लोकतंत्र का सबसे बड़ा मंदिर है। उस मंदिर में जो भी कोई बोलता है, अपनी आवाज प्रकट करता है, उस पर कोई मुकदमा नहीं हो सकता, नाइदर सिविल और नॉट क्रिमिनल, नहीं हो सकता। हमारे संविधान निर्माताओं ने इतना बड़ा अधिकार अनुच्छेद 105 के माध्यम से दिया कि संसद सदस्य संसद में बेवाक होकर अपनी बात कहेगा। यह प्रिविलेज है। एक चीज को हम नजरअंदाज करते हैं, यह अनक्वालिफाइड नहीं है। हमारे संविधान निर्माताओं ने इतना बड़ा अधिकार अनुच्छेद 105 के माध्यम से दिया कि संसद सदस्य संसद में बेवाक होकर अपनी बात कहेगा। तो हम लोगों का सदन में दायित्व है, उत्तरदायित्व है कि जो कुछ हम सदन में बोलें, जिम्मेदारी से बोलें, प्रामाणिक तरीके से बोलें। दिस प्रिविलेज कम्स विद वेरी हैवी रेस्पॉन्सिबिलिटी, and that responsibility is that every word spoken in Parliament must be after due thought. संसद को वो अखाड़ा नहीं बनने दिया जा सकता जहां फ्री फॉल ऑफ इंफॉर्मेशन हो।
Members of Parliament enjoy some special rights, immunities, exemptions and privileges. These are entrusted to them by Parliament. When any of these rights are disregarded or any offence is practiced against them, it becomes a breach of privilege. Our episode today is all about what are these parliamentary privileges, what constitutes their breach and much more. Come along with your host, Kriti Mishra. Parliamentary privileges are special rights, immunities and exemptions enjoyed by the two houses of Indian Parliament, their committees and members. The origin of parliamentary privileges in India can be traced back to when the Charter Act of 1833 added a fourth member to the Governor-General's Council. The Government of India Act of 1935 provided freedom of speech in the legislature. Today, some of the privileges of Parliament and its members and committees are specified in the Constitution. There are also certain statutes and the rules of procedure of the House, while others continue to be based on the precedents of the House of Commons. The main articles of India's Constitution dealing with the privileges of Parliament are 105 and 122. Each House of Parliament enjoys an inherent and exclusive authority to conduct and regulate its proceedings in the manner it deems proper. This right is a natural corollary in the immunity from proceedings in the court of law in respect of anything said or done inside the House. It is well settled that each House has the exclusive jurisdiction over its internal proceedings. No authority other than that of the House and its presiding officers has any say in the matters relating to the conduct of its proceedings. Accordingly, Article 118 of the Constitution empowers each House of Parliament to make rules for regulating its procedure and conduct of its business. Article 122 guarantees that the validity of proceedings of Parliament cannot be questioned in any court of law.
We are the ultimate architect of Constitution. There is no authority under the Constitution that can even look at issues that are meant for us.
Members of Parliament are entitled to the freedom of speech in the Houses. They are not liable to any court proceedings from the speech given in Parliament or its committees. However, the behaviour and speech of members are regulated by the rules and guide the provisions of the House. Parliament also has the right to receive immediate information about the arrest, detention, conviction, imprisonment and release of a member. The Indian Parliament can initiate any inquiries and has the right to call upon witnesses. Parliamentary privilege does not allow unquestioned latitude for members to do as they please. Rather, it is available to individual members only insofar as they are necessary for the House to perform its functions freely, without hindrance. They do not exempt the members from their obligations to the society.
Both the Houses of Parliament have their own Committee of Privileges to examine matters of privilege. The privileges are of three types: privilege of the member, privilege of the House, or privilege of the House, or privilege of the committee appointed by the House. A matter of breach of privilege starts with a motion moved by one of the members. It could be against an individual or against another member of the House. If the motion is admitted by the chairman, then it is referred to the Privileges Committee, either with the approval of the House or suo motu by the chairman. In a breach of privilege case, the offender may be pardoned if he offers an apology and if the Committee of Privileges and the House consider that it is adequate. Or the offender may be let off with a warning or some kind of advice not to indulge in such an activity in future. In extreme cases, the offender can even be sent to jail till the prorogation of the House.
One of the privileges is that a member of Parliament cannot be arrested in a civil case 40 days before the start of the parliamentary session or committee meeting and 40 days thereafter. This privilege is incorporated under Section 135A of Civil Procedure Code 1908. However, when it comes to criminal matters, MPs are on the same footing as other citizens of the country. No member is exempted from appearing before any investigating agency when called upon to do so by citing House duty. As lawmakers, it is their bounden duty to respect the law and the legal procedures. One cannot avoid the enforcement agencies or summons and notices of law enforcement agencies. If an individual or authority violates or disregards any of the privileges, powers and immunities of the House or members or committees, they may be punished for breach of privilege or contempt of the House. Misuse of the immunity contained in the member's right to speech and action in the House can seriously impact the rights and freedom of people who could have otherwise sought the protection of the courts of law. Besides offences against the authority or dignity of the House, such as disobedience of its legitimate orders or libels upon itself, its members, committees or officers also constitute breach of privilege. Contempt of the House may be defined generally as any act or omission that obstructs or impedes either House of Parliament in performing its functions, or which obstructs or impedes any members or officers in their discharge of the duty. Some of the important types of contempt of Parliament and breach of privilege include speeches or writings reflecting on the character or proceedings of the House or its committees or any member of the House relating to his character or conduct as a member of Parliament. Reflections on the character or impartiality of the Chairman, Speaker, in the discharge of his or her duties as a Chairman or Speaker. Publication of false or distorted reports of the debates and proceedings of the House. Publication of expunged proceedings of the House. Premature publication of proceedings, evidence or report of a parliamentary committee that is presented to the House or to the chairman. Obstructing members in the performance of their duties or while on their way to coming or after attending the House or a parliamentary committee. Offering bribes to the members to influence them in their parliamentary conduct. Giving false or misleading evidence or information deliberately to mislead the House or a parliamentary committee by a member or a minister. The power to punish any person who commits contempt of the House or breaches its privileges is the most potent weapon in the hands of a House of Legislature. This power gives reality to the privileges of Parliament, emphasizes its sovereign character and vindicates its own authority and dignity. It is therefore described as the keystone of parliamentary privilege. Each House of Parliament is the guardian of its own privileges. Courts of law in India have recognized that a House of Parliament or a state legislature is the sole authority to judge if there has been a breach of privilege or contempt of the House. The House may punish a person found guilty of breach of privileges or contempt of the House either by reprimand or admonition or by imprisonment for a specified period. In case of its own members, the House can award two other punishments, namely suspension and expulsion from the House.
Both Lok Sabha and Rajya Sabha have their individual committees of privileges. These committees examine matters of breach of privilege that have been referred to them by the presiding officer. These committees function in a manner wherein not only do they hear the viewpoints of the Member of Parliament whose privileges have been breached, but also the viewpoints of individuals who have indulged in the breach of privilege. Sometimes these committees also have to take a look and examine cases of breach of privilege matters where one Member of Parliament is claiming breach of privilege against another. Now the Privilege Committee has recommendatory powers. The committee can propose a range of penalties. So for example, sometimes the committee has issued a reprimand against a Member of Parliament, which basically means that the chair reads out a reprimand to a specific Member of Parliament on the floor of the House. In some other cases, the committee has recommended that the Member of Parliament be suspended for a certain duration. And in some very rare cases, the committee has also recommended that the membership of a Member of Parliament be taken away and their seats be declared vacant. The committee can also penalize individuals outside of Parliament who have indulged in breach of privilege. So for example, if somebody has reported an incorrect version of parliamentary proceedings, then that person can be brought before the Privileges Committee, and the Privileges Committee can direct an appropriate punishment either in the form of an apology or in the form of a reprimand to be issued to them. In some very rare cases, some legislatures across the country have also recommended a simple imprisonment of the offending individual in a jail for 1 or 2 days.
Chapter 20 of Rule 22 of the Lok Sabha and Chapter 16 of Rule 187 of the Rajya Sabha mention the privilege motion. Scrutiny regarding the privilege of this motion in the Lok Sabha is managed by the Speaker and in the Rajya Sabha by the Chairman. Once the Speaker or the Chairman considers the acquisitions to be true, then the accused are called to explain their conduct. A 15-member committee nominated by the Speaker in the Lok Sabha and a 10-member committee nominated by Chairperson in the Rajya Sabha manage all the cases and acquisitions related to the privilege motion and take relevant actions against the breach of the motion. Sunil Kumar Singh heads the Committee on Privileges in the Lok Sabha, while Deputy Chairman Harivansh heads the committee in the Upper House.
Members of Parliament and the institution of Parliament have certain rights and privileges available to them. These privileges are available individually to members of Parliament and to the institution collectively, so that members of Parliament can discharge their role as lawmakers effectively and for Parliament to be the hub of a deliberative democracy. So for example, one of the privileges that a Member of Parliament has is to be able to speak freely in both Lok Sabha and Rajya Sabha. whenever a member feels that their rights or privileges have been violated either by an individual outside of Parliament or by another member of Parliament, they can reach out to the presiding officer of the respective house and claim that their privileges have been breached. In such circumstances, the presiding officer refers the matter to the Committee of Privilege for it to give its recommendations. On certain occasions, the presiding officer of Parliament can also take suo motu action and refer a matter that they believe is a violation of the privilege of Parliament directly to the Privileges Committee of Parliament.
The chairman of the upper house is empowered to refer suo motu any question of privilege or contempt of the Committee of Privileges for examination, investigation and report. In doing so, the chairman need not bring the matter before the House for consideration and decision as to whether the matter referred to the committee. The chairman can also himself inquire into a breach of privilege matter and apprise the House of the result of his inquiry and close the matter. Article 105(3) of the Constitution leaves the Parliament to define their powers, privileges, immunities and of the members and the committees. The Indian Parliament has so far not enacted any comprehensive law. In this context, the question of undertaking legislation on the subject has been considered at various conferences of presiding officers. There have also been moves to codify the privileges in some other parliamentary democracies. Australia enacted its Parliamentary Privileges Act in 1987. It prescribes a maximum penalty of 1 year imprisonment and fine of 5,000 Australian dollars. It excludes the words spoken or acts done in the presence of the House of Committee from its protection. In the UK, a joint committee recommended in 1999 that a Parliamentary Privileges Act should be enacted, but the British Parliament is yet to do so. The opening and the last sentences of our preamble, "We, the people, adopt, enact and give ourselves this Constitution," signifies the power that it is ultimately vested in the hands of the people. Parliament is the supreme legislative body of India that reflects the will of the people. As in other parliamentary democracies, Parliament in India has the cardinal functions of legislation, oversight of administration, passing the budget, ventilation of public grievances, discussing various subjects like development plans, national policies and international relations. Parliament of India is the supreme legislative body and a living epitome of freedom and sovereignty of the people of India. It occupies a preeminent and pivotal position in India's democratic polity. Breaches of privilege or contempt of Parliament are impediments in enforcing accountability. Well, viewers, that's all we have for you in this edition. Thanks for watching and stay tuned to Sansad TV. Goodbye for now from my side.